Well, primarily a revocable living trust is a legal document that's designed to avoid probate. And probate is a legal process by which assets are passed to heirs after someone dies. The revocable living trust allows the client to avoid the system of judges and attorneys and that sort of thing. Well, a revocable trust is one that can be changed at any time. Assets can be placed in the trust and taken out at any time. And the client is basically free to cancel the trust at any time. Whereas an irrevocable trust, once assets go into it, it is irrevocable is just what it says. It's considered to be in place permanently, and it's very difficult now to terminate that trust, or more difficult to terminate that trust and get the assets out. Well, there are a lot of misconceptions about trusts. I think the biggest one is, I don't have a very large estate, and so a trust is not necessary. Trusts are more about control, and so for those people who have a desire to avoid probate, which comes with its own set of factors, such as it takes time, there's money involved, we have to deal, as I said, with courts and attorneys, there's a hassle when we're grieving. If none of that bothers you, then you're a good candidate for a will. If that's something you don't want to deal with, then the trust is the way that we avoid that. Someone would need a revocable and irrevocable trust in their planning for very specific reasons. The revocable trust would pass the bulk of the assets in the estate, but an irrevocable trust might be used in conjunction with that, for example, to shelter insurance proceeds from estate taxes, or to plan for special needs children. So there are very specific reasons why someone would use an irrevocable trust, and they could be used in conjunction with a revocable trust at times. Well, my personal opinion is that if someone sets up a revocable living trust, it would be malpractice on my part not to do a will, but it is a very specific kind of will. There are many kinds of wills and trusts, and the type of will that we would be talking about with a revocable living trust would be what is called a pour-over will. This is a will that acts to transfer assets that might be left outside the trust into the trust after someone dies, so that we shortcut the probate process and therefore kind of limit the expenses and the time that's involved in that process. Well, whether joint tenancy always avoids probate or not really depends on the specific situation. In about 95% of the cases or more, that's probably true. But if your joint tenant, for example, dies with you at the same time, let's say in a bad automobile collision, or if that person has predeceased you, or if they're incapacitated, or any number of issues where basically that person is no longer able to take control of those assets, then that joint tenancy with right of survivorship would not act to pass those assets to that person. There would still have to be a probate to decide where those assets go, because that person is not capable of taking possession of those assets. Living trusts are valid in all 50 states. In fact, it's the vehicle that we use to avoid probate in all 50 states. So for example, if a client has property in Texas, but also in New Mexico, or maybe a vacation home in Florida, we can help them avoid probate in all those states where they have real estate or other assets. Certain living trusts can protect assets against creditors, but it goes back to the question that we talked about earlier, which is, what is the difference between revocable and irrevocable trusts, or what is the difference between maybe a grantor trust or a non-grantor trust? Now, those are technical legal terms, so to put it more simply, if I have control of my own trust and my assets are in that trust, then I can get to those assets whenever I want to, and a creditor can force me to do so. If someone else has control of my trust, or if there are limitations placed on the access of the assets in my trust, then that can be a good way to shield those assets from creditors. Well, when considering a trust, I always tell my clients that it's not the size of the estate that matters. We want to talk about control and what matters to the client in terms of control. I have two basic philosophies that I deal with clients. The first one is, when something happens to me, I want everything to be seamless and easy for the people I leave behind. The second one is, after I'm gone, what do I care because I'm dead? So let everybody else sort it out. Depending on your philosophy and whether or not you want to help your heirs avoid probate and that process, or whether you don't care and want them to sort it out on their own, then that's probably the most fundamental reason to consider, do I want or do I not want a trust?